Good afternoon, everyone, and a warm welcome to today's lecture by Professor Neha Jain on escaping the cult of the robe, on international judges as individuals. Professor Jain's lecture will form part of the Amsterdam for Center International Law lecture series, and it's a special lecture for many reasons, not only because of the fact that we have Professor Jain with us, but also because it's on the occasion of the ACIL annual research day. So it's also for that reason a special lecture and occasion for us. And I want to start off, first of all, by thanking Neha for accepting our invitation and for agreeing to discuss one important or one interesting piece of research with us on escaping the cult of the robe. She shared a draft chapter with us on speaking separately, conceptualizing separate judicial practices, which forms part of a book that she is co-writing with Cosette Kramer. And there's wonderful original insight in there, and I can't wait to hear more about that work during your lecture, Neha. Just want to introduce you very briefly. So Professor Jain is a professor of public international law at the European University Institute, where she also co-directs the Academy of European Law. She's currently on leave from her position at the University of Minnesota. She has published widely. She's been very prolific, published in wonderful insights in very renowned, prestigious fora, including the American Journal of Comparative Law, International Law, European Journal of International Law, Harvard International Law Journal, and so on and so forth. Her distinctions are truly many and recognitions. Among other things, she serves as managing editor of ACIL Unbound and sits on the boards of the European Journal of International Law and the Criminal Law Forum. So it's with great interest and gratitude that we look forward to your lecture, Neha. So the idea is that you would speak for up to 30, 35, up to 40 minutes. And then we open it up for questions and answers. And we are recording that first part, the part of your lecture, and then we close the recording so we can be as free as we want to in our questions, and you can be even more daring in your answers. Let's see how that's gonna go. So it's without further ado, thanks so much again for joining us. The screen would be yours. Yeah. Thanks.
Thanks so much, Ingo, for that generous introduction. And thank you so much for having me here and for inviting me. Of course, I would have loved for us to do this in person. I adore Amsterdam. I adore various people on the faculty as well. But I'm hoping that this way, at least we get to be together, at least virtually. I've tried to bring a little bit of the European University Institute and Florence to you with this background. I am in one of the rooms in one of our villas. This is not what my home looks like, in case anybody was mistaken. So hopefully, we can at least be together in this virtual environment. And I'm excited to share this project with you, which is still very much a work in progress. So all good ideas begin with a good story. So I'm going to begin my talk also with a story. And the story is set way back in 2012. It is April. It's quite a frosty spring morning in The Hague. It's not raining, so at least we have that, given The Hague. And you have a packed courtroom, which is awaiting the historic verdict in the trial of the former president of Sierra Leone, Charles Taylor. Taylor appears unmoved as the presiding judge, Judge Richard Lusick, reads out the 44-page summary. I would hope that my students have shorter summaries for their research projects, but the 44-page summary of the judgment that is unanimously convicting him of war crimes and crimes against humanity. But as the three-member panel rises to leave, things take a rather dramatic turn. Judge So, who's the Senegalese jurist, who was the alternate judge in the case, begins speaking to voice his dissent or his disagreement with the majority verdict, or the unanimous verdict rather, considering he was the alternate judge. Undeterred, the judges continue to file out of the courtroom as Judge So, whose microphone has been cut off, can be seen speaking from behind the glass barrier. Someone has the bright idea then to put a metal grate over the glass barrier so you can't see him any longer as well, and we don't know what happens subsequently. Except, or rather we would have never known, except an intrepid stenographer who's writing down whatever Judge So is saying just as a general routine matter as they do in the courtroom proceedings, has actually recorded his statement. And this statement then begins to circulate amongst trial observers. And so we know now that in his dissent, Judge So laments the absence of any deliberative process amongst the judges, which forces him to voice his disagreement, he says, in this highly public and unusual fashion. Now, Judge So's public statement and the unexpected manner of its delivery causes consternation amongst trial observers, both insiders but also outsiders, because for one, it's exposed that there's clearly a strained relationship between the judges who are the members of the court, but it's also cast doubt in the prosecution case in one of the highest profile criminal trials in recent history. And so while commentators mostly acknowledge that as a formal legal matter, Judge So's dissent doesn't have any legal value since he was only an alternate judge, nonetheless, there's some concern that his public repudiation of the trial process, of his fellow judges, and of the verdict would set back any prospect of reconciliation between Sierra Leone and Liberia. So the question is, what motivates an adjudicator like Judge So to speak beyond and separately from the unanimous or the majority verdict, especially when he knows that his speech will have no formal legal effect? Does the form, in this case oral, or the style, which is quite confrontational, affect the content or the reception of the speech? Was Judge So justified in speaking out within the confines of the courtroom, or should he have waited to voice his objections and voice them outside the court, as in fact he did a few months later where he gave an interview with a magazine? And then was it correct to sanction him for his courtroom statement? Or should the statement simply have been expunged officially as a matter of the official court record? These and related questions are at the heart of the current project that I'm working on with my co-author, Cosette Creamer, who's a political scientist at the University of Minnesota. And we've been tinkering with this project now for on and off for about a year, as you do when different other projects intervene. But what we're interested in is what the structure, function, and the role perception of courts, especially international courts, would look like if we started taking seriously the phenomenon of individuals' judicial speech. And by this, we mean any incident where judges write separately, as they often do, when they dissent, when they concur, when they ask questions from the bench, when they publish academic articles, when they write memoirs, when they give speeches, such as the one that I'm giving right now. What functions do they perform? Do different forms of speaking separately contain the same connotation? So does an academic article, for instance, by a judge discussing her judicial reasoning, have the same resonance as a formal dissent? Is speaking separately an inherently public act, or would graveyard dissents also count? These are instances where the judge buries their opinion, and so it's never made visible to the public. Do all these count as speech acts? And what I'd like to do is to share with you today the conceptual scaffolding that we have built to start answering these questions. So we offer a typology of judicial speech, claiming that it falls at least along 5 dimensions of variance: formality, visibility, individuality, temporality, and collegiality. So for instance, we argue that some kinds of separate speech are more visible, they're more institutionalized than others. So others are hidden, they're more informal. Some are dialogically directed towards the fellow members of the court, whereas others are monologues. And some are purely individual acts, while others are collective speech acts that nonetheless remain separate from the court and the judicial entity. But for us, this attempt at identifying and categorizing the different forms of judicial speech and practice is not simply an academic exercise. In focusing on the various ways in which judges signal their individuality through judicial speech, we want to reorient the existing debate on international judicialization, which by and large treat courts as monolithic entities to produce an account of judicial behavior, practices, and conduct, and what the consequences of this behavior might be for international law. And we argue that our project has both normative but also practical implications for both the design of international judicial institutions, but also for stakeholder buy-in in international courts at a time when the future looks far from certain. Before I get into the meat of the argument, what I want to do is take you through a whistle-stop tour of the different forms of judicial speech and practice and conduct that we see at international criminal courts and at other courts, but both on and off the bench. And I will then lay out the typology of separate speech that we have developed, and finally consider some consequences and the stakes involved in different forms of judicial separate speech. And some of this will be very familiar territory to you too, so please feel forward to skip ahead. As most of you are probably aware, with a few very limited exceptions, the busiest and the most prominent international courts countenance the possibility of separate speech. So on the one end of the spectrum, you have courts like the International Court of Justice, the European Court of Human Rights, the International Criminal Court, where the governing sets of rules and regulations, including practice directives, clearly permits individual judicial speech. And then in the middle, you have courts primarily or adjudicative institutions, primarily those dealing with international economic law or international commercial law, such as investment tribunals, that appear more reluctant to embrace individual opinions. And then you have a strong preference for unanimity in dispute settlement bodies such as the WTO. If you look at the DSU, there is the preference for unanimity, and also in the fact that individual opinions, to the extent they're expressed, must be anonymous and not identifiable. And then on the far end of the spectrum, you have courts such as the CJEU, which is almost unique in completely avoiding any mention of separate opinions. And there have been various historical and other reasons given for this exceptional practice of the CJEU, including the fact that it's modeled on the French judicial system, where the idea is that all decisions are considered to be made and delivered in the name of the court as an entity and not in the name of individual judges. Of course, the rules by themselves don't tell us very much about how often judges actually use this institution of speaking separately. Because while the rules might provide an overall framework and also the limits within which this speech must happen, judges may or may not be inclined to actually speak separately, depending on a number of factors, which can be legal training, the political culture, the institutional environment, the amount of support they have for writing separate opinions, their own professional backgrounds, and of course, their own personalities. And in this context, we see ICJ judges, for instance, who are probably the best or the worst offenders, depending on how you think of this practice, who are the most prolific users of separate opinions. Indeed, a unanimous judgment is a vanishingly rare phenomenon in the International Court of Justice, but also courts and judges such as the European Court of Human Rights judges are not too far behind. There have been a few studies studying the practice of the European Court of Human Rights, and roughly about 60 to 80% of the judgments, depending on how you count, have at least one separate opinion. Separate opinions, including dissents, are also on the rise in investment arbitration. Roughly a fifth of all published cases in investment arbitration contain a separate opinion. And similarly, notwithstanding the fact that international criminal courts such as the ICC have had very few cases so far, whether at the trial level or at the appeals level, it's obvious that separate opinions are a fixture in the International Criminal Court. In contrast to these tribunals, there's still a very strong norm of consensus in decision-making at the WTO. So we've seen very few separate opinions, and in the rare instances where they do appear, they're often buried. So the tone is very apologetic, they're quite short, and they're sometimes buried within the appellate body report, or in some cases even in footnotes. But written individual opinions still give us only a partial snapshot of how active and engaged judges are in making their voices heard. And here we see that international judges are active, increasingly active, both within and outside the courtroom. And this can have negative consequences for them. So one of the most controversial fallouts of this hypervisibility has been the incident in the WTO, for instance, where the US refused to approve the reappointment of appellate body member, Mr. Chang, on the basis that he had been activist in the way he had participated in a particular proceeding. Now, this was rather strange, considering that the appellate body reports, there is no way of identifying on their face who has authored them, since they're signed collectively by the appellate body members. But what the US did was rely on the questions that Mr. Chang had put during the proceedings, saying that they could be used as evidence to attribute authorship to him of his activist stance. So now we have some idea of the various ways in which international judges speak. But then the question arises is, what does all this judicial chatter mean for international law? And our short answer is very different things, depending on the type of judicial speech at issue. And so as I said at the outset, we place the most salient forms of judicial speech along 5 dimensions of formality, visibility, individuality, temporality, and collegiality. And let me begin then with the first variance, where we classify speech as formal, semi-formal, or informal. So for a moment, I want you to stop and think about what is the first thing that comes to your mind when you think about separate judicial speech or a judge speaking separately. Chances are most of you have probably thought of a dissent. Maybe if you're very creative, maybe a concurrence. But of course, these are not the only forms of speech that occur. They represent only a very small fraction of the numerous ways in which judges make their voices heard. And this is especially true of systems in which judges are highly visible public creatures rather than anonymous civil servants. So one of my backgrounds is in domestic systems such as the United States, where you have an overtly public profile of the occupants of its higher judicial offices, especially judges of the Supreme Court. And the judges themselves seem to be remarkably willing and open to embracing the distinction, the blurring of the boundaries between their public and their private lives. One example of this was the late Justice Ruth Bader Ginsburg and her ascendance to the status of a pop culture icon who transcended both the generational divide, but also low and highbrow culture. So she became the subject of a biopic, an opera, a Saturday Night Live character, action figures, tattoos, T-shirts, even a meme with the phrase, "I dissent." But you have a similar trend taking hold in a couple of other countries, especially common law countries, such as the United Kingdom, with a former president of the Supreme Court, Lady Justice Hale, also having become a household name and being labeled the Beyoncé of the English legal profession. In the international context, we don't have any Beyoncés, at least not just yet, but we do have judges who've acquired a fairly high public profile. Historical examples would be cults of celebrity in specific areas of international law. The person who comes to mind most readily is Judge Radha Binod Pal of the International Military Tribunal for the Far East, who was also the subject of a recent Netflix historical drama miniseries. If I'm not mistaken, the Dutch actually co-sponsored the production of that miniseries. So judicial speech occurs in multiple fora outside the courtroom, and it straddles the divide between formality and informality. But if you look at the scholarship on either domestic courts or in international courts, it focuses primarily on formal speech, and it focuses primarily on dissenting opinions, not even concurrences. Other forms of speech that might be employed by a judge, especially outside the courtroom, and what its consequences are, is largely ignored. For instance, there's virtually no scholarly analysis of oral dissents in the context of courtroom proceedings in international law, even though it's clear that choosing to speak orally has a very different resonance from doing the same thing in writing. The oral opinion conveys and embodies immediacy, especially in a world of live media updates and the Twitterverse, that the written opinion simply lacks. And when delivered in charged circumstances, just the Charles Taylor trial, it not only demands, but it also commands both public and media attention. Again, in a way that a written legal text can rarely approximate, especially for non-lawyers. But beyond the oral dissent, judges formally speak from the bench, also in the form of questions and statements, as in the case of Judge Chang, who then had to pay for it. And there are really very few scholarly studies of this type of judicial practice. And what we do find is, again, entirely in the context of domestic rather than international law. For example, it's been argued, again in the US context, that US Supreme Court judges are much more likely to ask more questions and be more sharp and abrupt as a matter of prediction of whether the party will eventually lose the case. Conversely, they also use humor and laughter during oral arguments, both as an advocacy tool, but also as a status signal. And while formally, questioning during oral arguments is directed towards the counsel or the advocate who's appearing in the case, in practice, judges also seem to use questioning for their fellow judges in order to build coalitions. Interpreting the reasons for and the effect of this type of judicial questioning is complicated. Though again, when we come to international courts, we have some forms of evidence that we can pass. For example, scholars have pointed to the extensive witness questioning in the case of the International Criminal Tribunal for Rwanda, and have put forward the argument that this questioning on the case of sexual violence crimes was actually crucial for the trial chamber subsequently having them added to the indictment. Interpreting judicial behavior gets even trickier once we move outside the courtroom to situations where judges deliver public lectures, where they write articles, where they participate in symposia. And typically judges are quite careful to say that whatever they say in these circumstances cannot be attributed to their official role, they're speaking in their private capacity. But it's not always easy to isolate, or at least fully isolate, these statements from whatever they might be saying in their public capacities or as judges. And nor is it entirely clear that we as the audience are always meant to do so. A prime example of this illusion are the frequent out-of-court statements on a range of legal issues by the CGEU or by judges of the CGEU, perhaps as a compensation for the fact that they're barred from voicing their opinion separately within the context of the courtroom. And finally, informal judicial speech may take the form of statements by judges that are ostensibly divorced from the public role or from even the judicial role, but are nonetheless intended for public consumption. And this mode of speaking is more common, again, perhaps in the common law systems like the United States, where judges have sanctioned biopics and biographies and works of fiction and nonfiction, but the phenomenon is certainly not unknown in international law. If you take, for instance, the recent memoirs of Judge Karl Baudenbacher, the former judge and president of the Court of Justice of the European Free Trade Association states, the memoir gives an insider perspective, or claims to give an insider perspective, on the court, while casting doubt on the extent to which judges are actually free from political interference. Is it plausible for a judge to claim that whatever philosophical, political, and normative positions that they adhere to in these reflections that are the work of fiction or part fiction must be cast aside when we want to predict or construe what they said in their legal capacities? Does such informal speech possess independent legal salience, given that the judge's voice is both solicited but also amplified by the fact that they have a former or current judicial role? Our second dimension of separate speech is visibility. Must a judge voice an opinion publicly and prominently in order for it to count as separate judicial speech? Now, there are numerous examples, of course, of judges opining in highly distinctive and visible ways, but you don't have to have a separate opinion that is prominently labeled as such. The Hybrid War Crimes Tribunal, the extraordinary chamber in the courts of Cambodia, for instance, has at least one instance where the dissent is buried within the judgment. It's been a paragraph in the judgment in the case of Doik. And so the opinion is accessible primarily to court insiders or even ECCC insiders, and it's an unlikely candidate for broader public dissemination. Within the court, judges also talk in different ways. They circulate and exchange memoranda, letters, notes, and emails that may never see the light of the day unless there's a public information request and they're found in some archives later on, much beyond their tenure. For instance, the ICJ requires each individual judge to formulate and circulate a tentative opinion that then forms the basis for the internal judicial deliberation. And some of these individual opinions may eventually be buried for the sake of unanimity, especially in a high-stakes political dispute. But the internal draft opinions may nonetheless actually influence the deliberations of the court. And if they could indeed be found and uncovered, they may help us make sense of opinions later on. This is illustrated by an incident that's recorded by Hugh Thirlway when he recounts his time at the ICJ registry. And apparently the committee in charge of drafting the court's judgment at the time explicitly modified its reasoning in response to Judge Oda's draft dissenting opinion. A fact which did not please Judge Oda as much as one might expect. Instead, he remarked, "Mr. Thirlway, you keep moving the targets that I'm firing at. How am I supposed to keep up?" Even less visible are instances where a judge expresses disagreement internally over the procedure, over the reasoning, or the outcome, but there's no public trace or expression of this disagreement. Following the tradition in civil law countries, the CJEU, for example, has a single judgment requirement, which effectively erases any sort of dissent, at least from public record. And scholars have noted that this requirement, in combination with its general style of writing and the court's French working language, significantly shapes the intelligibility of the judgment and contributes to the uncertainty of EU law. Now, why would judges want to do that? To refrain from nailing their colors to the mast if they disagree so strongly? And there can be several reasons for that, both personal as well as institutional, including the desire to avoid incurring the wrath of those who appointed you, career ambitions in personal cases, or even preserving an outwardly united front, especially in cases that are highly controversial and have political implications. The choice to do so, though, will impact the reach of the separate opinions reasoning by obscuring it from public knowledge and from public scrutiny. Our third dimension of separate speech is individuality. Now, critics of separate opinion often point to their associated costs for interpersonal and working relationships. In this view, you have a romanticized lone dissenter who proliferates, whose proliferation of strident separate opinions represents a threat to collegiality. Yet, even in the formal judicial context, a separate opinion is not always individualistic, and it may even exhibit or contribute to the collegiality of the court. To be sure, at times a judge stands alone. When speaking through individual monographs, individual separate opinions, during oral questioning in the proceedings. But at other times, a judge speaks separately as a member of a collective, such as when issuing a jointly penned separate opinion. Again, jointly penned separate opinions are fairly ubiquitous in international courts, but we know very little about what motivates a judge to actually jointly pen a separate opinion rather than speak separately or not speak at all. One explanation is that the prevalence of this practice increases as the number of judges on a given bench increases and decreases as their diversity decreases. So the logic is that if you have more colleagues on the bench, presumably you can find at least one person with whom you agree, and then it's simply more efficient for you to team up and jointly pen a separate opinion than each of you do your own separate work with all the time and the resources that are involved. So the practice of joint separate opinions could be shaped by workload, by legal culture, or even by professional incentives. So in the context of the European Court of Human Rights, for instance, we see quite a lot of joint separate opinions. And one of the rationales given for this joint separate opinion practice is that separate opinion writers get no support on drafting from the Secretariat, so it's more efficient for them to pool their resources and time. Domestic and international judges also rely, of course, on other kinds of entities, such as legal assistants or law clerks. Some of you have been in that position, I'm sure, in different courts and tribunals. And law clerks and legal assistants are used, again, for a variety of reasons. They're used to conduct legal research. They may help in drafting opinions. They may assist in preparation for oral arguments and suggest questions to the judges. And American judges frequently describe these relationships as collaborative, with clerks as partners or alter egos, or a team of horses in a harness. And the relationship, in fairly intense terms, as the most intense and mutually dependent one outside of marriage, personhood, or a love affair. Now, this public discourse is markedly absent when it comes to international tribunals, where the role and contribution of legal assistants or legal clerks is mostly acknowledged in fairly generic terms. But if we look at the institutional structure and the practice of different international courts, it's clear that at least in some cases, these legal assistants or their functional equivalents play an important role. So for example, we know from the WTO or from WTO insiders that WTO panelists sometimes ask questions that are clearly prepared by the Secretariat. And in a number of international courts, one or more judicial assistants are present for the hearings, for oral arguments, passing notes, and communicating between themselves during the course of the proceedings. And such practices raise a host of questions, both conceptual and normative, that when judges pose questions that are prepared by another entity, such as a secretariat or a clerk or an assistant, who bears responsibility for what is said? Or put differently, who is speaking? And at what point does the involvement of non-judicial actors in the decision-making process overstep the bounds of legitimacy? So I have two more dimensions now. The fourth dimension that we highlight is temporality. Judicial speech has a temporal orientation, which is often linked to the motivation behind speaking separately. So if the intent for the judge by speaking separately is to persuade litigants or her colleagues on the bench, the judge will orient her remarks to the present context. At other times, though, she's oriented to the proximate or even distant future, where the intent is not just to influence fellow judges, but also future litigants, legislatures, other courts, future judicial majorities, or the next generation of law students, in the hope of shaping policy or jurisprudence. This is particularly true of dissents that have been characterized as appeals to the future. In the international context, for example, the dissenting opinions of judges, such as Judge Trindade of the ICJ, have been described as an attempt to acculturate the epistemic community of international lawyers, and of whom it's been said that if Cansado did not exist, it would be necessary to invent him. But these attempts at judicial communication are not without controversy, and they've generated some scholarly debate as to the appropriate judicial behavior and the balance between seeking to persuade one's colleagues and risking alienating them altogether by repeatedly dissenting. International judges themselves have also disputed whether international judges should in fact be using separate opinions as a vehicle for speaking to the future. So on the opposite end of Judge Cansado Trindade, you have former ICJ President Judge Tomka stating that the opinions should not be used as a platform for producing more academic pieces or a platform for announcing the law, as it should be in the future. Other ways of speaking separately, such as academic articles or policy memos on court operations, similarly orient the performative force of separate judicial speech to future developments. A striking example is how heavily involved former and previous and sitting judges of the European Court of Human Rights have been on debates relating to the reform of the European Court of Human Rights. A number of judges have written policy papers and articles and given speeches that weigh in on the reform debates from Protocol 11 to Interlaken and beyond. It is worth noting, though, that while the judge themselves may focus on certain types of content or adopt a particular style of form of speech with a certain audience in mind, in practice, they will have precious little control over how and why the speech gets taken up by various audiences. Present-oriented individual speech may take months or years even to percolate into wider public consciousness and debate. Though a judge can try and influence this and hurry this along in different ways. So judges at international criminal courts, for instance, you have Judge Pal, but also Judge So, who've used a variety of media, ranging from speeches to magazines. I think Judge Latanzi at the International Criminal Tribunal for the former Yugoslavia gave an interview in a woman's magazine, nothing to do with the law, on her dissenting opinion. This might, though, raise concerns about judicial propriety and the limits of direct engagement with external stakeholders. I will turn to these considerations in a moment after the last category, which is the dimension of collegiality. Not all instances of speaking separately are acts of defiance or acts of rebellion. Indeed, appending a separate opinion may be motivated by a desire to bolster the reasoning of the majority or of the court. Dissents and concurrences can also be a way of engaging with your fellow judges in a visible dialogue on the substance of the dispute. Separate opinions can thus be more or less monologic or dialogic based on whether the speech is in conversation with the other members on the bench, or if it's primarily oppositional in character. Dialogic separate opinions include a wide range of voices in terms of style and content, but what is common to this category is that though the judge is choosing to speak separately and individually, she is not questioning the legitimacy of the court or the legitimacy of her fellow judges. Whether assertive or deferential, the dialogic opinion is typically respectful of the authority of the court and of the authority of the judicial process. In contrast, monologic separate opinions are not addressed completely or not even primarily to one's fellow judges. The monologic opinion is forcefully individualistic in its tone and in its outlook. And to the extent that any remarks are addressed to one's fellow judges, they do not exhibit the hope or expectation of a continued dialogue. This refusal to engage can come at a serious cost to civility and to the court's legitimacy. This danger is evident in monologic opinions both on and off the bench, the way we see them in international tribunals. A good recent example of a monologic extrajudicial opinion is Australian Judge David Ray's litigation before the Special Tribunal for Lebanon. In a series of motions filed before the court, Judge Ray contested the appointment of judges to the trial chamber, tried to prevent the swearing in of a fellow judge, and subsequently accused the president of the court of breaching the norm of judicial impartiality. A judge, as opposed to a party to the dispute, filing a motion before the very court of which he is a member to disqualify another judge is fairly unprecedented in international law. So what is at stake in disaggregating separate judicial speech the way I have done, in identifying dimensions along which judicial speech may vary? We argue, in short, that words are politics. When a judge speaks separately, she potentially speaks to multiple audiences, both intended as well as unintended. A judge's colleagues represent her most proximate audience. Dissents, concurrences, draft opinions, notes, memoranda, etc., may help the judge convince her colleagues to adopt a different finding or a line of reasoning, though they may not always be happy about that, as we see from Judge Oda's reactions. But even if this attempt at persuasion is unsuccessful, separate opinions can force the majority to engage with the reasoning of the separate opinion, either in private, in the hope that the dissenting judge will actually bury the dissent and be persuaded to not issue it, or in public as a way to demonstrate that the majority took the reasoning in the separate opinion seriously and into account. The parties to the case represent the next immediate audience. A dissent or a concurrence may either vindicate the position of the losing party, or it could provide alternative support for the winning party. It may also influence lawyers in how they think about future cases or about changing their litigation strategy, either in future cases or at the appellate level. But separate opinions could also have negative consequences vis-a-vis the parties. For example, scholars have worried that for tribunals like the ICJ that deal with high-stakes political disputes without any enforcement mechanism to enforce their judgments, the increased cacophony that's produced by an in-house band of official critics will negatively impact the enforcement of ICJ judgments. The legal profession as a whole, including other courts and the legislature, constitutes the next proximate audience for separate judicial speech. At their most consequential, visible separate opinions actually become future law. And this change can be mediated by the courts themselves, but also through lawmakers and lobbyists who rely on formal, semi-formal, and extrajudicial statements to propose legislative change. Speaking separately may also be consequential for more distant stakeholders, constituencies, and the broader public. Monologic opinions and oral dissents can be used by judges to signal their displeasure to the press, the people, and the other stakeholders, and to dramatize disagreements and tensions within the court itself. And finally, separate judicial speech can be directly consequential for a judge's own judicial career. Oral questioning, for example, may be taken as evidence of a judge's formal position on a factual or a legal issue and have serious political repercussions, both for the individual judge, but also for the dispute settlement mechanism as a whole, as we saw in the case of the WTO. And for us, appreciating this range of potential consequences of separate judicial speech means recognizing that direct judicial engagement with stakeholders will always involve trade-offs. It raises a set of normative questions about expanding judges' power and influence within international society. For example, the public interventions by European Court of Human Rights judges in debates over the reform of the court raises normative separation of powers questions, given that reform is legally in the hands of member governments of the Council of Europe. It also raises questions about the role of judges as public servants, who have the authority to influence the fates of individual citizens. As such, speaking in the public sphere and participating in broader discussions could be viewed as essential elements of democracy and accountability. This is one of the rationales, in fact, put forward by advocates for separate opinions at courts like the CJEU. The argument is that with the enlargement of the EU in 2004, there's even greater need for transparency and democratic accountability at the CJEU, and that separate opinions are an essential part of this endeavor. To conclude, what I've tried to do in this talk is to highlight the different ways in which separate judicial speech can contribute to demystifying the court, as well as the judicial process. Judges do not simply carry out the standard functions that we would expect if we were to look at their mandates in a treaty text. Rather, they engage in highly visible, formal and informal activities where they effectively strip away the cloak of the judiciary or the mask of the law, thereby humanizing themselves and indirectly also the court. In the next steps of the project, we want to turn to more fine-grained empirical work on the implications that this may have for the perceptions of and confidence in international courts. And your comments and questions will be very helpful for us as we continue to develop both our conceptual categories and also how we want to investigate them. So with that, I will stop. Thank you for your attention, and I look forward to your comments.